there, Natalie Teston, family law lawyer in Gainesville, Georgia, coming to you today to talk about property division. In your divorce case, the court will have to divide any and all marital property that exists at the time of the divorce. So step one, what constitutes property for purposes of what we do in our divorce cases? Well, property is a very big, all-inclusive term here in our world. It means any real estate that you may have, any vehicles such as cars, RVs, boats, airplanes, any accounts such as bank accounts, savings accounts, certificate of deposits, mutual funds, all that type of stuff, retirement accounts, pensions, military retired pay, all of those things are included in property. And it's important to remember that in property, we're not just talking about assets, we're also talking about debts. So that would be credit card debts, lines of credit, anything that you've got out there, mortgage, all those type of things counts as property. So how does the court divide these items between parties in a divorce case? Well, the rule here in Georgia is that the court must equitably divide them between the parties. So yes, the word equitable comes from the word equal, but here in the state of Georgia, the court is not confined to a 50-50 split of assets. The word equitable in our case law means fair. And so the court does have a series of factors in our code that they look to figure out what is fair in anyone's particular circumstances. So again, we're trying to give these judges the opportunity to really be surgical in their approach and come up with a resolution that makes the most sense in the case that's in front of them at the time. Some of the factors that the courts look at are the financial circumstances of the parties. Is a 50-50 split of a retirement account fair? If the husband is earning $500,000 a year and the wife has been a stay-at-home mom for 20 years, maybe not, right? The separate estates of the parties. Let's say that even though the wife in that same scenario was a stay-at-home mom, her grandfather just passed away and she just inherited $2 million. Okay, so not on the table for us to divide here in this case, but something for the court to consider. Maybe 50-50 is fair or more fair in those circumstances. That sort of balances the scales a little bit if she's got her own separate estate. Contributions to the household, who was there doing the work of raising the children and going to work and contributing to paying the bills, all that type of stuff is relevant. And then we've got our ugly conduct factor that's on there. Who's drinking? Who's being abusive? Who is cheating? Who is doing all sorts of wrong things in the marriage? Who is the cause of why we're here today in a divorce case anyway? That's relevant. The court can move to a 70-30, 60-40 split on some of these assets to give a nod to the person that is more of the innocent spouse, if there's such a thing in these cases, or to somewhat punish the person that is at fault for why we're here today in their particular divorce case. So a big question that's out there is, what happens when an asset is mixed? What about my separate property? How do I keep that safe? Is that on the table for discussion here in the divorce case? Those are great questions, and they can be very complicated. There's two lines of cases that are out there that say different things, but they're both good case law. The first one is the Lurch case, which says title controls, meaning, let's take our example from before, stay-at-home wife and $500,000 a year earning husband. Let's say husband had $100,000 in a bank account prior to the marriage, and he used that money as the down payment on the marital home. Well, the Lurch case would say, if that home is jointly titled, the deed is in both of these folks' names, thank you, husband, you've made a great contribution and gift to the marital estate. That money that was your separate property is all marital, all on the table, up for division in this case. Can go 50-50, can be whatever. So that's one line of cases. Then we've got another line of cases, which is what we call the Thomas rule or the source of funds rule. Again, says different stuff, still good law, right? Very complicated. That says, no, we're not just gonna call it a gift. We're gonna dig into this and we're gonna try to figure out a fair way to divide this and to give each estate a proportionate return on its investment. And each estate meaning the marital estate and then also the husband's separate estate. So let's use a real world example of this. Let's say husband put that $100,000 down on the home. And then during the course of the marriage, the parties paid down $50,000 of the principal from the mortgage. So the source of funds cases say you need to look at the equity paid, like literally the dimes that are reducing the principal balance debt on this particular asset. So in this case, equity paid would be $150,000, right? $100,000 from the down payment and then $50,000 of principal reduction during the marriage. So there's $150,000 of equity paid in this case. And then we try to figure out, well, which estate, the separate or the marital, contributed to that. And so in this case, there would be a 2/3, 1/3 ratio, right? If it was $150,000, the 2/3, 100, came from husband's separate estate, and then the last third, the last $50,000, came from the marital estate. And so the court would say, okay, now you look to see what the real equity of this asset is, and you divide it per that ratio. So if the home is now worth $400,000, there's a $300,000 mortgage on it, the equity of the residence that's really up for division in this case is $100,000. 400 minus 300, right? Okay, and then we use our ratio to say, okay, the first 2/3 of that, $66,666.66, that's husband's separate property. He gets that straight off the bat. That's not up for division. The remaining $33,333.33 is marital property that's up for division in this case. That doesn't mean wife gets the 33. That means that gets divided. And so let's assume that the court does a 50-50 division of that. Okay, so wife's walking away with $16,000 or so, and husband's getting the lion's share of that. So that's how the source of funds rule works. As you can see, we need a lot of documents, right, to figure out those dollars, those numbers to put into the math equation. And if you are dealing with one of these cases, it's important that your lawyer be good at math and also be familiar with the judge, because the judge can literally go either way, right? The judge could have said 50-50 on the whole equity in that case if the judge was following Lurch. And if the judge wanted to look into Thomas and use the source of funds rule, well, the wife wouldn't get $50,000 or so. She's down to about $16-something thousand. So again, it's important to know what way you've seen those particular judges lean. And again, I think that case law is out there to give judges options. So again, that they can do whatever is fair in a particular circumstance. If a marital asset, well, I'm gonna put it this way, if a separate asset grows during the marriage, what happens then? That's another question that we get. Let's use our same example as before. Let's say before wife got married and became a stay-at-home mom, she had worked for Home Depot for 5 years. And during those years, she had contributed to their 401k plan. So at the time of marriage, she wasn't working there anymore. She wasn't contributing to it anymore, but there was $20,000 in her Home Depot 401k. Now let's say during the marriage, just due to market forces, that 401k rose to $30,000. Does husband have a claim to that $10,000 rise in value? It rose during the marriage, right? Well, our case law says no, if it's not due to active work, labor, and efforts of the parties. Just the market doing something to an asset, not marital. That's not marital. So that whole retirement account would be wife's in that particular situation. So as you can see, these issues are complicated. We've got conflicting rules. We've got a statute that says, here's all the factors the court can look at, and then anything else that the judge thinks is fair. This is where we bring the art, not the science, to what we do in divorce law. So again, it's just really important that you have a lawyer that understands both lines of cases, that will go and seek out all the documents that you need so that you can properly run this math equation needed, and that's familiar with the particular judge in your case to give you real world advice on, hey, I've had 10 of these types of cases in front of this judge. I've seen Lurch twice and I've seen source of funds the other 8 times. We better knock out our source of funds argument so that we're locked and loaded and ready to go for court. Thanks, guys. Thanks for tuning in. And if you've got any more questions, leave them in the comments and we'll address them in the next video.